Hi, Ben Carrasco here. Today I want to talk to you about one of the most important considerations in your child custody case, which is who is ultimately going to decide the issues in your case. Is it going to be a judge or is it going to be a jury? Few people know this, but Texas is actually the only state in the country that allows juries to decide certain questions in child custody disputes and in divorce cases. And today I want to focus on one issue in particular that a jury can decide, and that is which parent has the exclusive right to designate the child's primary residence, and relatedly, the geographic boundaries within which that parent can designate residence. Up until a recent Supreme Court decision, the conventional wisdom among family law attorneys was the only reason to ask for a jury trial in a child custody case in particular was if you wanted to move. So the bulk of my cases are in Travis County, Williamson County, Hays County. If I had a client come to me and they're going through a divorce and they want primary custody of their child and they want to move to another city or another state, or if it's a custody modification, maybe they finalize their divorce or their custody case several years before and there's been a material change in circumstances, perhaps they've gotten a promotion or a new job opportunity in another state and they want to be able to move with the child, then the conventional view was you will have a higher likelihood, still perhaps a low likelihood, but a better likelihood at winning with a jury than you will with a trial judge. Because the view among most family law attorneys is that trial judges are hostile to moves. That in the absence of extraordinary evidence, egregious facts, the other parent is abusing the child or has been neglectful or there's family violence or the other parent is just simply not involved in the child's life. Absent something really compelling like that, a judge is unlikely to allow you to move. I think the probability of prevailing with a jury is also relatively low, but the thinking is that a jury is going to be more sympathetic, that you at least have better odds with a jury trial in a move case than you would with a judge in a bench trial. Outside of moving, there were few reasons. There wasn't really an incentive to ask for a jury demand or make a jury demand in a child custody case, because all of the other issues, like what is the possession schedule going to be, which for a lot of people is the most important consideration, who's going to have more actual physical possession of the child, that's decided by the judge. The judge decides who is going to pay child support and what amount. And any other terms and conditions of conservatorship, whether there's going to be alcohol testing or whether somebody has to submit to a drug test or whether there's going to be any injunctions or whether you have to communicate on a co-parenting app, all of those things are decided by a judge. So the questions that a jury can decide are relatively narrow. And the view was, if you don't want to move, there's really no reason to make a jury demand, because you could, let's say the case is in Travis County and nobody has a desire to move, you could do a jury demand. The jury could give you the exclusive right to designate primary residence in Travis County, and the judge could still end up giving the other parent more possession time in order you to pay child support. So what's the point in asking for a jury? Now that changed with a recent Texas Supreme Court decision called Gopalan v. Marsh. And in that case, which also originated in Travis County, Dad filed a jury demand, had a jury trial, 5-day jury trial, very contentious case. Dad was not asking to move. He was asking for the exclusive right to designate primary residence within Travis County. And Mom was making a similar request, although she wanted an even narrower geographic restriction. She wanted to designate residence within, I believe it was Austin Independent School District. Dad ended up winning. The jury awarded him the exclusive right to designate primary residence. Nevertheless, the trial judge in that case actually gave Dad less than 50% possession. He got a standard possession order, not even expanded standard, just standard possession schedule, first, third, and fifth weekends of the month from Friday at 6 to Sunday at 6, Thursdays from 6 to 8 p.m. I don't even think he got the standard 30-day summer possession time. It was from his perspective, he got the shaft. He got less possession time than Mom. And he filed an appeal, and he lost at the Intermediate Appellate Court, the Third Court of Appeals. The case law was somewhat divided on this issue, but the appellate court, the immediate appellate court, relied on on the language in the family code, which says that, essentially says that the judge decides the possession schedule. Notwithstanding what the jury may do, the appellate court ruled the judge has a discretion to decide the possession schedule based on the best interest of the child. He appealed to the Texas Supreme Court, and he won. And a decision that came down, I think it was in June, maybe even early July of 2026, the Texas Supreme Court ruled that a trial court cannot contravene a jury verdict by giving the non-primary parent more possession time than the parent who is awarded the right to determine primary residence. Importantly, the court held that equal possession time, 50-50 possession schedules, is still permissible. So you could have a scenario where, in this case, dad was awarded the exclusive right to designate primary residence, and it would not be improper in that instance for a judge to award both parents equal possession time. But it would be improper for a judge to award the primary, for lack of a better word, I'm going to use the shorthand, the primary parent, the primary custodial parent. It would be improper to award that parent or a contravention of the jury's verdict to award that parent less than 50% possession time. So now we're operating in a world where you arguably have an incentive to file a jury demand even if you don't want to move, because now if a jury awards you the exclusive right to designate primary residence, that does have implications for what the judge can do with the possession schedule. So a lot of dads come to me, they want 50-50 possession schedules. And we have a standard possession schedule in Texas, and I tell them, look, you're not likely to get that if you go to trial. Judge is going to look at best interests of the child, and one parent is going to have a majority of the possession time, and the non-custodial parent is going to get the standard possession schedule. Now, though, you arguably have an incentive to do a jury demand. Because if you go to a jury trial and a judge, let's say your dad in this scenario, and a judge awards you the exclusive right to designate primary residence within Travis County, then I think arguably the judge has to give you at least 50% possession. I think it's somewhat of a tragedy that more litigants do not ask for jury trials. In fact, in the state of Texas, less than 1%, I think it's 0.5% of family law cases are decided by juries. And I think that's unfortunate because the right to trial by jury is a sacred right. I think litigants accept decisions, are more accepting of decisions that are made by a group of 12 people hashing it out in a room who bring their own life experience and their own common sense to bear on a question than one arbitrary judge or one judge who makes a decision sometimes arbitrarily. Everybody has biases. Jurors have biases. Judges have biases. But do you want 12 people with perhaps different biases deciding your case, or do you want one elected partisan judge to make all of the decisions in your case? It's an important tool. It's an important right that I think people too casually forfeit. And it also gives you a powerful source. If you file a jury demand in your family law case, I think it gives you a powerful source of negotiating leverage against the other side, because there are a lot of lawyers out there who are intimidated by jury trials. They don't have a lot of experience trying cases before juries, and they're going to start hyperventilating when they see that jury demand and push their client to settle on potentially terms that are more favorable to you if you're the one asking for the jury trial. So I'm expecting that we're going to see, in the wake of this decision, Gopalan v. Marsh, I'm expecting that we're going to see an uptick in jury demands, and you're going to see more litigants, particularly dads, rolling the dice with a jury, even in cases where they're not asking to move, because now it does have implications for the possession schedule. So something to keep in mind. I have experience with jury trials. I have won jury trials on behalf of dads. And if you want to explore this option further, I encourage you to reach out to me and schedule a consult. We can talk more about it. Thank you.